Good afternoon, everyone. Welcome to our March 11th webinar on 10 things associations are required to do that they may not be doing. My name is Alina Gilbert. I'll be presenting today. So hello. I hope everyone's doing well. Let's go through our housekeeping things real quick and get a little comic relief here, and then we'll move straight on. All right. So first of all, thank you again for participating in our webinar. On your screen, most of your screen should be the PowerPoint, and on the left side is me. Hello. Uh, on the right side, you should see a little chat icon, and that's where you're going to type any questions you have throughout the class. I am saving all questions until the end because I want to make sure we have enough time to get through the materials, and also some of the questions that you post may get answered later on in the presentation. So I do save those for the end. If you are having any audio or video issues as we go through the webinar, there is a little clicky button at the bottom that says audio or can't talk, audio or visual problems. Click on that. It's going to take you through a few steps. Hopefully it will fix whatever issue you are having. You will get one CMCA credit for attending today as long as you stay on the whole time. It is automatically generated. It gets emailed to you. You should have it today or tomorrow at the very latest. If you don't, please reach out to us so we can see what's going on with it. If you haven't been on the webinar the entire time, it may not have generated, and we do have a requirement with CAMICB with respect to how long somebody needs to stay on for them to be able to get a credit. So we're not able to really mess around with those timing requirements. So I tell everyone, just stay on for the whole thing. So when you get your email with your certificate, first thing you should do is save a copy of the picture of the certificate because it disappears after 30 days. I don't know why, but it does. So please take a picture of it, print it out, whatever you need to do to save it and preserve it. We are recording today's presentation, and it will be on the YouTube channel once it's reviewed and approved. So probably, by tomorrow or the day after, should have it on the YouTube channel for you. And at the end of the presentation, you are going to have a little pop-up survey that is going to ask you some questions about the class, about me, the presentation, the contents. If you have time and the inclination, we always appreciate feedback. Helps us make our classes better, and it helps us also learn kind of what you are looking for perhaps in future events, or what you want less of or more of. So we would really appreciate any feedback you can give us. So that being said, we've got 10 things to go through. Let's go through them. Let's start with number 1, which everyone should already know, right? Adopt your 9 good governance policies. I won't read them off for you. You can read those yourself. I'll have the Kiowa section at the bottom for all these requirements. This is 209.5. If anyone wants to go and read it, there's a copy of Kiowa on our website if anyone's really interested. But you do have to have all 9 of these policies. It's just historically, if you recall, 2005 is when it all started. We originally had 6 policies, and 7 policies, then 9 policies. So it's been adding on over the years. So we have 9 now. And if you don't have one of these, or you're not sure if you have one of these, you probably want to make sure by looking through the records. And if you need one, make sure you get one. What if we don't have one of these policies? You're in violation of the law. And arguably, a homeowner could bring legal action against the association for failing to comply with the law. And that owner would prevail. Even if you adopt the policy afterwards, they could still ask for their legal fees that they spent to go after the association to force compliance. So we really don't want anyone in that kind of a situation. Uh, the other thing to be aware of is the collection and enforcement policies, especially. If you don't have an up-to-date one, and as you know, collection keeps changing. Our latest revision was last October. So if you haven't had your collection policy updated since 2025, since before 2025, you are likely not working with a compliant policy. And if you're not working with a compliant policy, you don't get to collect your assessments or foreclose on your liens. So you really want to make sure you have one. Your enforcement policy also needs to be compliant, or you cannot enforce your governing documents, at least not in court. So those are very important. The rest of the policies are also important. And a big question I get about these is, Alina, do we have to have a separate document for each of these? Can we have it all in one document? What if we already have this in like our bylaws or in our declaration? Do we still need to adopt these? The answer is, it doesn't matter if you have something in your governing documents, you need these 9 policies. Our recommendation is each of the 9 policies be separate documents. They should not be incorporated into your rules or any other documents. They should each be a standalone policy. However, if for some reason you don't want to do that, at a minimum, Kiowa says the collection policy must be a standalone policy and the enforcement policy must be a standalone policy. So at a minimum, you're going to have those 2 be separate documents. But ultimately, we want all of them to be separate documents because we never know when we're going to have to update a document. And it's a lot easier to update your document when it's not part of a big, giant document with other policies in there. So anyhow, that is requirement number 1. Let's go on requirement number 2. Provide notice and hearing before imposing fines. Now, I know a lot of you are sitting here going, Alina, we know this. Why'd you even put it on here? Well, and I put it on here because 1, it is a requirement, but 2, although everyone inherently knows that this is required, I don't think everyone inherently understands what it means. And so the first thing is, it means you never, 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 ever can do immediate fines. I see so many rules where there's like, if you do this, you will have an immediate fine. No such thing. In Colorado, we cannot have immediate fines. You always got to have notice and opportunity to be heard. It also means nothing's going on the ledger until after notice and the hearing. What happens if someone doesn't request a hearing? Arguably, the board should still have a hearing in which it makes the decision that there is in fact a violation on this property, and we do want to impose the fine. Those hearings, those discussions should be in executive session, given some recent legislative changes to Kiowa. And you definitely want to make sure you're discussing these in executive session. If a hearing is requested, great, hold the hearing. You don't need to talk about like your decision at the hearing in front of the homeowner. That's something you can do after they leave. But ultimately, nothing's going to hit their ledger until after they get the letter saying that a fine may be imposed, and they are either scheduled a hearing or they are told, here's where you can call or email to schedule the hearing. And they have either scheduled it or they have failed to schedule it. And we have talked about it as a board in executive session and decided, yes, there is a violation there. That's what that means. It doesn't mean we send a letter that says you are in violation, you can call a hearing, but we're imposing a $50 charge against your $50 fine, and you can come have a hearing to talk about whether or not you think you are required to pay this fine. That's not what that means, right? It means we're not putting anything on their ledger and nothing immediate. All right. Next. Creation of a membership list. That's something that's less known, I think, but nonetheless required. You have to create the list and you have to make it available to your homeowners if they request it. through an appropriate records request. And what does it have to have on there? So it's got to have the names of the homeowners. It's got to have their physical mailing address. And that means it's the address where we send notices. It may not be the same as their unit address in the community if they're offsite owners. So it's got to have their mailing addresses on there, not necessarily their unit addresses. It also has to have the number of votes each unit has. And that's not something I typically see anyone put on the list. And ultimately, I think most homeowners who request these lists from associations don't realize this has to be on there, and therefore nobody mentions it. But for your edification, it does have to have the number of votes per unit on that list. So you might want to get in the habit of doing that, because next time you get a homeowner requesting the list, if they have an attorney or they are an attorney and they're bored and they got nothing to do but read through Kiowa, they will eventually find that requirement and accuse you of not following the law and not giving them the appropriate membership list. What don't we have to put on the list? Well, the obvious kind of missing provisions are email addresses and phone numbers. So under Kiowa, we do not provide email addresses and we do not provide phone numbers. The only time that can be provided is when you get affirmative permission from the homeowner. And that means either they've filled something out and signed it, or they've affirmatively clicked a box somewhere that says, yes, you can include this information, like if you have a directory. But other than that, associations are prohibited from giving out that kind of information. So if you right now have a directory for your community and you've got everyone's email address or phone number or both, and you haven't gotten affirmative approval, you better be getting rid of that and removing all the phone numbers and emails, because that is a violation of Kiowa. It does not allow you to do that. So if you send an email to an owner and you say, if you don't respond to this email in 10 days, we're going to treat this as a yes, that we can post your information. Can't do that. They have to actually do something. So they have to either respond and say, yes, go ahead and post it, or you give them a form that they fill out that says, yes, we can post it, but they have to take affirmative steps to approve it. And it can't just be a failure to respond as a yes. Okay, so this is pretty serious. And I have seen associations get into some trouble when they have inadvertently disclosed this type of information pertaining to their homeowners, not realizing they weren't supposed to do it. So just be very careful. Make sure you don't share that information. Make sure it's not on your list. And if you are going to share it, make sure you have affirmative approval from the actual owner to do that. All right. Number 4, keep common elements open for use, for the homeowners and the residents' use. So this one, that one gets a lot of attention every so often, because it really essentially prohibits associations from closing off common areas because they can't afford to maintain them, or because they don't want to maintain them, or because they're not getting used in general. And what this says is you cannot unreasonably restrict or prohibit owners from accessing or enjoying a common element unless, right? So here's the unlesses. Unless they're closed for maintenance, repair, replacement, or modification, and there is a reasonable safety concern for residents or the workers if people are allowed to enter, or it's required for preservation of the structural integrity or the condition of repair. So this is the only time we can really close off access to common elements. Now, notice this doesn't just say like the swimming pool or the clubhouse or the tennis courts. It says common elements. So we're talking about all common elements here. Even that little green strip of land that lies, behind the complex somewhere that no one uses. None of it can be really closed off under the statute. Now, remember, this is unreasonably restrict. So what is a reasonable restriction? Well, a reasonable restriction would be an amenity that is a seasonal amenity. So, for example, if you have an outdoor swimming pool and you're closing it for the winter, that would justify a reasonable reason to close and not allow access. But if you have an indoor pool and you close that during the winter, that would not be considered reasonable because it's indoors. I had a conversation with someone just the other day about tennis courts, and the question was, "Hey, can we go ahead and close off the tennis courts because it's winter?" And I said, "Well, given the kind of winter we're having, aside from a couple of days here and there, it's it's pretty much tennis season, right? It's 70 degrees out. It's 60 degrees out. It's sunny. And so we might have a harder time arguing that a seasonal closure for the tennis courts would be appropriate at this time. And so, you kind of have to use a little bit of common sense. Now, there is more to this, and that is if you're ever closing a common element for more than 72 hours. So, for example, the seasonal pool closure would be more than 72 hours. There are requirements. One is you have to send a written notice to every single homeowner at their address. You can do it by email, or you can do other delivery, such as snail mail, hand delivery, but you've got to deliver it to every single homeowner. You've got to tell them the reason for the closure. You have to tell them when you expect reopening that common element. And you have to give them either a phone number or an email address where they can reach out if they have specific questions. That is a requirement. So, those of you who are closing your pool seasonally and not doing this, guess what? That could be held against you. That could and would be viewed as a violation of Kiowa. So make sure you're sending these notices. There's another requirement, and that's to post physical signage at every single access point of that common element. So if you've got two access points to your outdoor pool, one from the clubhouse and one from the outside, both have to have signage, and it has to have exactly the same information in that signage as it did for what you sent to the homeowners, exactly the same notice requirements. Um, so think about whether or not you've been doing that. If you are closing the pool for repairs and it's going to be a week-long repair, you're going to have to do the same thing. You're going to have to get those notices together. You're going to have to put those signs up. If you're closing the tennis courts to resurface them and it's going to take more than 72 hours, again, you're going to be putting the signage up there. Any common element that's going to be closed longer than 72 hours. So keep that in mind. And I know it's a pain in the butt, but I also know that there are a lot of communities out there that are closing for more than 72 hours that are not posting these. And no one has really called them on it because I don't know that a lot of homeowners know about this, but all it takes is someone to read the statute and to realize that, hey, you got to be posting signage and sending notice. Okay. Let's go to number 5. Public disclosures. That's a fun one. So this is really, I think it sounds more onerous than it is, but it is a requirement, and we need to make sure that our communities are complying with all of this. So my first question is what? What do we have to disclose? You can read the check marks of all the items that are required to be disclosed. Just a couple of comments on this. Name of the association and the name of the common interest community could be two different things. Some of your associations, the legal name is ABC Townhomes Inc., but you just go by ABC Townhomes. So that's slightly different. So the name of the common interest community is going to be a little bit different than what you go by as the association. So again, you need to make sure both of those are disclosed. Management company, designated agent, addresses, phone numbers, blah, 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 recording information for the declaration. You can read all of this, right? So all of this has to be disclosed. Um, as far as insurance information goes, we typically get questions about that as far as what does that mean? Does that mean we have to disclose our full policies? Generally, we say the declarations pages for your insurance, which are like, those cover sheets that have the summary of here's what's covered, here's how much, here's the deductible, that type of a thing. So those summary pages is what really you need to post. If a homeowner requests copies of the entire insurance policy, they're certainly entitled to it. But as far as the disclosure piece goes, you are in compliance if you just do those summary pages. So that's the what. Let's talk about the when. The when is there's two whens. 90 days, within 90 days of when the developer transitions. So that's a one-time disclosure, right? Because you only transition from developer control hopefully once. So 90 days after that, it's got to be disclosed. And then it's 90 days after the end of every single fiscal year. So, but here's the part that makes it not so horrible, and that's the how. How do we disclose this? Well, one way to disclose it, which I hope most of you are using, is to post it on your website. Okay, so to have all of the stuff on the website. Most associations that I know that I work with have this on their website. However, there's an and the and is if you're posting it on the website, you still have to send notice to every single homeowner, either by regular mail or by email or by personal delivery. Oh, no, sorry, I take it back. Mail or email is what you have to send them notice that this is all on our website and give them the link. Okay, so you still have to send that. The other option is you can provide all these disclosures by mailing it or personally delivering it to each owner. Unless you've got like a community of 2 units, you're probably not going to be doing that. And then the last option is literature table or a binder at the principal office. What's the principal office? In most cases, it's the management company. If you're self-managed, the principal office is probably going to be one of the board members' homes. You may not want to keep a literature table or a binder there. If you're not sure who or what the principal office is, you can go to the Secretary of State website and look up the association because it is a corporation. And when you look it up, it'll tell you right on there where the address of the principal office. So obviously, the easiest thing to do here is to post it on the website and shoot an email to all your owners or mail them saying, all the stuff's on the website. Here's the link, right? So that is really how you comply with the public disclosure requirement. And it's pretty easy for the most part. So don't miss out on this one. Even though I'm sure most of you are doing this, I think a lot of folks forget that they still have to send a notice to the homeowner saying that we have it on our website. So don't forget that part of it. Okay. We're halfway done. I will let you enjoy a little comedic curly for a minute. This is so I can drink water. All right. I love Jerry Seinfeld. I think he's hilarious. All right. Shall we move on? All right. Let's got to number 6. Ensure all common elements. And this is for post-Kiowa communities only. Okay. And how do you know if you're a post-Kiowa community? We created after July 1, 1992. How do you know when you're created? This is one that most people get wrong. They always tell me, well, that's when your articles of incorporation are filed with the Secretary of State. And I say, no, that's not the right answer. The community is created when the declaration is recorded. So you have to look at the recording information on the declaration. And any declaration recorded on July 1, 1992, or any time after that is going to be considered a post-Kiowa declaration for a post-Kiowa community. Okay, so Kiowa says All limited common elements and all general common elements must be insured by the association. Doesn't matter where they're located. It doesn't matter if your declaration provides something completely different. You are required to carry property insurance on common elements. Some examples, perhaps. I have seen situations where we had townhomes, and the declaration required that the homeowners insure their patios. But the patios were actually not on the lot. They had zero lot lines, so the patios were actually lying on the common elements and were therefore limited common elements assigned to individual, townhomes. And the declaration said owners must maintain and insure all their patios. Well, guess what? Yes, we can make the homeowners maintain the patios, but they could not make the homeowners insure the patios. So kind of part of the problem here is knowing what's a common element and what isn't a common element. And sometimes it's not clear. With condominiums, obviously, our decks, our balconies are considered limited common elements. They're going to be outside the airspace. And so, if you have a provision that says, hey, homeowners are responsible for insuring these things, and you're a post Kiowa community, that's not going to fly. That is something that conflicts with Kiowa, and the association still carries the obligation to insure those components. And, a lot of times associations will go to their insurance representative and say, here's a copy of our covenants, insure whatever they require, which is really what you're supposed to be doing. Except that sometimes the covenants aren't real clear. And these legal nuances, as far as what's a common element, what's part of the property, what's a limited common element, that is something that really requires a legal opinion. And so I would encourage you, if you have a community that's post Kiowa, where it's not entirely clear kind of where the limited common elements are or who has to do what, that you get a legal opinion from whoever your counsel is, so that you can share that with the insurance representative and say, hey, these are the common elements. We need to make sure we're insuring these various components, or get a maintenance and insurance chart prepared where it lists out all the components and tells you who has to insure that. I know when I've talked with various insurance agents and brokers, they really appreciate the charts, because then they don't have to guess, and they just go ahead and they insure whatever the chart says association has to insure. So that's just food for thought. But ultimately, just know, if you're a post July 1, 1992 community, you have to insure everything that is deemed a common element. Let's talk about post Kiowa community some more, and insurance, because if you're a post Kiowa condominium community, you also have to insure the condominium units. Right. So what does that include? It includes your drywalls, it includes your windows, your doors, all your fixtures that are installed inside the unit, your countertops, your bathtubs, ceiling fans, cabinets, toilets, you name it. All of that is part of the unit. Now, these fixtures, as they were originally installed by the developer, are the association's obligation to insure in a post Kiowa condominium community. Again, it does not matter what your declaration or other governing documents say. This is the statutory requirement. But the bright side is we can exclude a few things. We can exclude finished surfaces inside the units. So what would that mean? So things like your carpet, your wallpaper, paint, paneling, hardwood floors, anything that kind of goes over the drywall or over like that subflooring, that type of thing, that's going to be considered a finished surface that associations are allowed to exclude from coverage. But be careful, Because if your declaration says you have to insure these components, you still have to insure these components. Kiowa says this is the minimum of what you have to insure, but your declaration can specify more than the minimum. And if that's what you have to comply with that. Okay, so the other thing we can exclude is owner installed improvements, which means if I replace my countertop with something nice, then technically I, as the homeowner, am responsible for making sure that's insured as opposed to the association because it's no longer an original installed fixture. Okay, so those are the things that may be excluded. There's nothing else that Kiowa allows for us to exclude in a condominium community. So it doesn't matter if you amend your declaration to remove those requirements. It doesn't matter. We still have to ensure the bare minimum, which is the units minus finished surfaces minus owner installed improvements. And as the last bullet says, the declaration can require us to insure more, but it cannot allow us to insure less. Okay. So we teach whole classes just dedicated to this. So I know there's a lot of probably questions with respect to these various things. And I understand. And if you have some, type them in and we can try and get to them at the end of the class. I think we will have some time left to do questions. All right, provide owner education, another requirement. Wow, so many requirements. So, and this one still surprises some people when I tell them. And yes, it is a requirement under Kiowa. It does apply to all communities, regardless of when you were created. So you have to provide education for your homeowners at least annually at no cost. And the good news is it can be any format you want it to be. So Kiowa's not real specific on that. It doesn't matter. What it says is you got to provide at least once a year, no cost. And you got to, the topics have to be related to like the operation of the association, rights and responsibilities of owners or the board. So basically it has to be an association, related topic, but how you present it is up to you. So examples of education that I've seen associations do. I have had associations, I've had managers call me and say, hey, I like that newsletter article you guys posted. Can we distribute that to our homeowners as part of the education? Sure. Great. Can we have our insurance agent come to the annual meeting and talk to homeowners about insurance? Sure. That could be the annual education. Can we have the attorney come and answer questions about specific things as part of the owner education? Sure, we can. So ultimately, the good news is that the format can be almost anything you want it to be. But what we always want to make sure we do with the education is we want to make sure that you're designating it somewhere and in writing as the annual education component, because what we don't want to do is have one of your homeowners who's not real thrilled with the board or the association or that special assessment he had to pay the other day, go and accuse the association of not actually having the required homeowner education in the last year. And you say, well, sure, we sent this newsletter article from Altitude about this, and that was the education. And he said, no, that wasn't. Well, we didn't label it as the education piece. So we really have no way of proving that that was intended to be the education piece. So whatever you end up doing for the education, just make sure that you are labeling it. So if you're having someone come to the annual meeting, like, the CPA, the attorney, the insurance agent, whoever, the engineering contractor is going to talk about all the things that are wrong with the building. Make sure that your agenda says annual homeowner education. CPA will attend to discuss blah. If you're sending a newsletter article, make sure it says this is for the annual homeowner education requirement, this article. Please read. So it doesn't have to be anything huge or big. It just needs to be labeled as the education. Okay. So hopefully everyone's doing that, and everyone will continue doing that, and will continue specifically labeling it. Aha. Obtain owner approval before transferring common area. Again, post Kiowa communities only. So if you are a post Kiowa community, regardless of anything your declaration might say, or rather, regardless any lower number your declaration might have, you're going to need approval from 67% of all your owners in the association to transfer common area. Okay, that's a big number, but that's a requirement under Kiowa. Okay, now your declaration can have a larger percentage. It can't be lower than 67, but it can be like 90%, 100%. So you could have a much higher requirement in your declaration itself. But absent that, it is 67% of all your votes in the community. So it's a pretty high standard to meet, which means associations are going to be, it's going to be difficult to get rid of common element. And I have a lot of associations that are like, well, can we sell our common elements? Can we sell them? Can we give them to the metro district? Well, if you're a post Kiowa community, you got to get 67% to sell them or to give them to someone to transfer title. You do not need 67% approval if you're just going to contract with someone to come in and maintain it on your behalf, like a metro district. That's not we're not divesting ourselves of title in that case. But if we're going to change the title on it, rise to 67%. If you are trying to get rid of common elements that include limited common elements, every single person, owner, who has the use of those limited common elements must approve. So the other day, I was talking with one of the attorneys here, and she said, I have a board. They have like a parking structure, and half of those spots in there are assigned for use to individual units, and they want to get rid of it. Now, there's a lot of issues with that to begin with, but ultimately, what we came up with was not only do they need 67% of all their owners to approve that, they're going to need every single owner who has an assigned parking space in that garage to also approve that transfer. So if you are thinking of transferring, make sure, and in your post Kiowa community, make sure you are aware of this little requirement. If you're a pre-Kiowa community, then it's whatever your declaration says. And sometimes the declaration doesn't say anything, which means you don't need homeowner approval, because the Nonprofit Act specifically allows nonprofit corporations to sell or transfer title to their real estate. So if you're an older community, you are probably in a much better position than the post-Kiowa community. All right. Last but not least, do we need a drum roll here? I guess not. Okay. Allow owners to speak prior to the board voting during board meetings. I bet you all knew that one. I just want to point out some very specific things, though, with this. One is you got to allow it prior to every single vote. The question I get most often is, can we just like do it in an open forum at the beginning? People have the agenda, let them talk about everything on the agenda, and then we'll move on. No. I mean, you can let them talk about it, but you still have to open it up for comment prior to each board vote. So there is, you can't do it all at once. Who gets to talk? Well, it can be an owner or the owner's designated representative. Who's a designated representative? It could be anyone that's designated as a representative in writing. It has to be a written designation. Now notice it's an or, not an and. So it's an either or. And if you read Kiowa and you read about who is entitled to also attend meetings, it is also the owner or their designated representative. So ultimately, you can tell the homeowner pick one or the other. You can't both be here if you really want to. As far as speaking, I definitely would recommend narrowing it down if you've got a representative there and the owners there. I mean, if it's okay with the board that they're both there, I would say only one of them gets to speak. Okay, what else can we do? We can impose reasonable time restrictions on how long people get to speak. So we can say we will allow people to speak for 5 minutes and then we're going to vote. If it is a highly contested issue that the board is voting on and you got people on both sides of the issue, what Kiowa says is you got to allow a reasonable number of people on each side of the issue to speak. So what you can say is, all right, we got 80 people in here. We're going to let 3 people speak for this, 3 people speak against this, and you each have 2 minutes. That's absolutely appropriate. And Kiowa says we can do that. So that's okay. The key here is you gotta allow it before every single vote. And that's really where I see associations struggling, is they seem to think that it's not before every single vote. Okay. Uh, the other thing I get asked is, well, what about if a board makes a decision outside of a board meeting? Then are they in violation of this requirement under Kiowa? Well, the answer is no. Why? Well, because making decisions at a meeting is a completely different legal process than making a decision outside of a meeting. We have a separate provision in both the Nonprofit Act and in Kiowa that talks about here is how the board takes action outside of a meeting. And there's nothing in those provisions requiring homeowner comment. And the homeowner comment is only required when you're making a decision at a board meeting. So I have a lot of misconception here where people think, oh, if we make a decision outside of a meeting, we got to go back and then ratify it at a meeting and let the homeowners comment. You absolutely do not need to do that, but you do need to keep copies of all the emails in the whole chain as far as when you ratified this. And that chain is available to homeowners to inspect and copy if they ask for it. You don't have to post it like the meeting minutes, but if a homeowner says, I want a copy of the exchange, or I want a copy of the documentation concerning this decision the board made outside of a meeting, they would be entitled to a copy of that email chain. So you want to be very careful what you put in the email chain, because you don't get to just cut and paste pieces of the chain that you want to give the homeowner, which is why when you are voting, what we typically say is start a brand new email chain with an email that says, we are going to vote on blah, here are the options, here's when we need to submit the vote, and do it that way. Start it as a brand new chain, because otherwise whatever came before that is going to be part of that chain. And if you got discussions in there where you're saying Bob's a jerk and Mary is a what, you don't want that part coming up and being given to the homeowners. Hopefully we don't have language like that. But again, ultimately, the only thing we really want in that chain is all the voting, the email that starts it with all the required information, and then the actual votes. That's all we want. But you do not need to go back and ratify it. And I see a lot of associations doing that, and there is a little bit of a risk in that, because well, what happens if you go back and you vote to ratify it? Let's say you made a decision outside of a meeting to contract with ABC Landscape. Board president signs the contract. 2 weeks later, you have your board meeting and you are ratifying it. And now all of a sudden, Two of the three board members have doubts about this company and they don't vote in favor of ratifying. What are you going to do? There's nothing you can do. You've signed the contract in reliance on the decision. So ratification really is not a necessary thing. I don't recommend you do that. Now, the main time, usually you will ratify a decision if it is questionable whether the original vote was valid. So we had somebody on the board who wasn't, a proper board member. They weren't an owner. The board made a decision. We can go back and ratify that decision to make sure it's kosher, right? But we don't need to ratify decisions that were made outside of a board meeting just because they were made outside of a board meeting. That's not necessary and it's not recommended. Okay. Guess what? I think I will let you look at this one. I love dogs. I love when they have an attitude. All right. So let's go do some questions. We got 15 minutes, which is amazing. Enjoy the dancing pig and the dancing chicken. I am going to start at the very bottom, so bear with me. I got to scroll here. All right, first question. Do small associations under Kiowa have to have the 9 good governance policies? Yes, unless you are an exempt association from Kiowa. There are exemptions for planned communities with 20 or less units. However, it can never, if you're a condominium, you can never be exempt. If you are non-residential, I believe, you may be able to be exempt, but the key here is look for 20 units or less and then have legal counsel review your declaration to see if you truly are exempt. If you have more than 20 units, you're not going to be exempt, except if you're a large planned community, but that's like huge acreage. So it is possible. Does a hearing need to be scheduled even for late fees to be applied, even after proper amount of notices have been sent? No. So that's a good question, because the hearing, owners are only entitled to a hearing before fines. They are not entitled under Kiowa for a hearing before we impose late fees or interest, or if we're doing a chargeback because someone was negligent and the association incurred fees and we're charging them back. Kiowa does not require hearings or notice really prior to that. So if your documents require it, you'll need to do it. But otherwise, there is no requirement to do that. What is your opinion on putting the membership list on the document portal? I think that's something you can do, assuming it doesn't have that prohibited information in there. My experience has been that when associations do that, some homeowners tend to get really upset with them because they don't like that being posted. And so I think it's more of a political question versus a legal question, because legally it's not prohibited. All right. Do you consider short-term rentals to be a timeshare unit? No. Timeshare units have a very specific definition, and it's truly increment ownership. It's not leasing. Leasing does not make a unit a timeshare unit. What if a community does their own directory but do get permission for the information? Do we need to collect copies of the permission and keep them on file somewhere? Well, that I would recommend that, because if somebody comes back and says, you put my information up there without my approval, you definitely want to be able to point them to something saying, no, here, you click, you approved here, you checked the box, you signed your name. So I would absolutely keep those, whether it's a piece of paper or an email, because people forget and then they accuse you of things. Can we close the pool because of the lack of water/drought this year? Nope, that's not going to be an appropriate reason under Kiowa. Remember, the only appropriate reasons are maintenance, repair, replacement, and saying we don't have enough water, it doesn't fall under any of those. It's not maintenance, it's definitely not repair, and it's not replacement. So you're not going to be able to do that um, because of the drought. I know. I mean, I don't necessarily, I don't think it's a good rule. I'm just saying that's what it says. How recent have there been changes necessary to the 9 required policies? Well, last year we had a change to the collection policy. So as early as last year, I believe the enforcement policy was 2 or 3 years ago. So was the inspection of records was like 2015. I mean, we've had a lot of changes over the years, and we don't know what's going to happen this year. So we will have to wait and see on that one. What if there is constant vandalism of amenities and repair costs have exceeded the budget? Can you still not close it? I mean, technically, under the statute, it's no. So, what can you do? Well, maybe you can get rid of those amenities and replace it with something else. That is a whole separate analysis that your attorney will have to do to see if you can. I've had associations say, well, nobody uses the pool. Can we put cement in it, fill it, and then put a playground on there? So that is a separate analysis. You'll need to talk with the association's legal counsel to see if these things that we have are just being vandalized. Can we remove them? Can we have something else here that isn't subject to that? So that's what you would be looking at. But ultimately, the statute, the way it reads, it doesn't allow for us to close for that. See, if an HOA holds USTA tournaments and junior tennis lessons and matches, must the HOA keep one court open and available for owners to use? Not necessarily. I assume when you allow these tournaments that they are not lasting 24 hours a day, 7 days a week. I assume they're just like a few hours and they're not every single day. So it's okay. And they're being used. So we're not like cutting off access, and reasonably we're allowing them to be used for tournaments, and I think that's okay. Could we get in trouble for closing our pool off from residents when our clubhouse has a wedding booked? The wedding venue is right next to the pool and we close it when we have those events. No, I think that would be, again, reasonable. And what you're doing is you're allowing a resident to use it for a private event, and that's fine. We're talking about closing it off because we don't want to maintain it, or we don't want to deal with it, or we don't have money to deal with it. Closing it off temporarily for like a few hours in the evening because there's a wedding, that's absolutely fine. It is a reasonable restriction for a community lodge to be locked for security when it's not rented. I think so. Unless you have something in the lodge, like let's say you have a workout room, that probably wouldn't be reasonable in that case. But if it's just like a lodge and it's used for events and we keep it locked when it's not being used for events, that's fine. Remember, it's using the common element for its intended purpose, right? So if the intended purpose is you can lease it, then that's fine. We can lock it when it's not in use. Sorry. I have an association that states in their governing documents that homeowners with a past due balances do not have access to the pool or clubhouse until their balance is paid. Is that legal? Yes, if they have that in their governing documents, that is lawful, and that's not considered really cutting off access as much as it's a penalty. And if you're not paying for using this, you don't get to use this. What are let's see. What about closing the clubhouse during the holidays? Again, if the intent of the clubhouse is that it's used for booked events, then yes, you can keep it closed, until it's booked. If the clubhouse has amenities in it, such as a workout room, a sauna, then in that case, again, it has to be a reasonable closure, which means if we don't have anyone to staff it, we can close it for that time. But if it's more than 72 hours, we going to have to put up the signage that we talked about. Ultimately, we really want to be able to keep it open though, because anytime we close it, somebody could claim we're in violation of the statute. Restricting pool use if a person is in collections by deactivating pass. Yep, we just talked about that, and that is absolutely fine, assuming your governing documents allow for that. Let's see. We have a pond that supplies raw water. We do not want people fishing in the pond. Can that be enforced since it is a commonly owned element? Yes, yes. You can have rules governing the use of common elements. So that would be an appropriate use. We're not closing it off. We're not saying you can't go look at it. You can't, look at the pond. We're just saying you can't fish in it. So I think that's fine. Let's see. Would you recommend updating the directory with the public disclosures, or do we have to do it every time there is a transfer of title? You don't have to, I think, do it every time, but if you're talking about the membership list, it should be getting updated, because if you're sending notices out to homeowners, you got to know who you're sending them to. So the expectation is that it gets updated as properties get sold. It doesn't, and since we're not posting that list on the website, it, just gets updated. Let's see. For public disclosures, does all the info need to be in one document or just accessible, listed separately through the website? Yeah, it just needs to be accessible. I think it would be a pretty big, long document if you put it all in one document. In fact, most associations on their website, you can click on each thing and it'll take you there with a link. What about limiting access when assessments are not current? Okay, we talked about that. Does owner training / education need to change every year? Yeah, you don't want to repeat the same thing over and over again, because arguably you're not really educating then. You're just repeating the same thing over and over again. So I would make sure that you have something different every year. If you send out an email notification, do you have to send out the mailing notification on the same day for those we do not have emails for? The statute doesn't say it has to be the same day, but I would do it as close as possible to the emails. Certainly not more than a few days apart. Can you expand on the requirements regarding the phone / email policy? Can we post on the website that the owner is responsible for updating their contact information and that is enough? Yeah, you can. In general, owners are responsible for providing the association with their updated information, their contact information. Now, if the property sells, usually hopefully the title company is giving you that information. But if not, I know management companies kind of have their own way and their own processes for figuring out or, looking whether or not that a unit has sold. Owner education. How does that pertain to renters living in the home? Is the owner responsible for forwarding the education materials to the renter, or is that the responsibility of the HOA board? It is not the board's responsibility for renters. There's no requirement to educate renters. It's just the owners. So you do it for the owners, and if the owners want to forward it on to their renters, they can, or they can choose not to. The homeowners being able to speak before a board vote, does that apply for any board vote made during a meeting? Yes, any board vote during a meeting. Sorry. All right, I'm going to do one more because that's all we have time for. Um, How do board members and homeowners access the Kiowa statutes in the Colorado Revised Statutes? They can do a Google search. They can go to our website. We have both the nonprofit and Kiowa on there, so it's easy enough to do it. And that, I'm afraid, is all I have time for. My email is on here. If you wanted to send me an email, if you have questions, I will try to get to them within the next few days. I'll do my best. Please don't get upset if I don't get to them right away, but please feel free to send me an email and I'll try to get back to you. And thank you so much for joining us today, and we'll see you next time.